Big news in the Ripple versus SEC battle. A new motion has been filed to resolve the lawsuit, and there's a lot to unpack here. Yesterday was an avalanche of updates, and I'm just catching my breath. The good news, enough time has passed for some of the top legal minds in the XRP community to weigh in. Yes, I'm talking about Attorney John Deaton, Attorney Bill Morgan, and Attorney Fred Rispoli. Their insights bring some much needed clarity to this whirlwind. So where are we headed? Well, according to two of these legal pros, there's a good chance the judge might call it. This case could be wrapping up. But let's not get ahead of ourselves just yet. Stick around to dive into their perspectives and see what might be next for Ripple, XRP, and the entire crypto space. This could be big. One attorney seems even less sure this will happen after the latest filing. Hard to believe, right? There's still a good chance it'll wrap up, but nothing set in stone just yet. You'll see what I mean as we break it all down here. But before we dive in, let me make one thing crystal clear. I'm not a financial expert, not even close. This isn't financial advice, and seriously, don't make any buying or selling decisions based on what I say or write. So remember the last joint filing by the SEC and Ripple? Yeah, Judge Torres wasn't having it. They hope to wrap this whole thing up like, hey, let's just call it a day. But after nearly half a decade of this legal tango, you've got to imagine her patience is wearing thin. Some even speculate she's over it, thinking, really? After all this time, now you two want to play nice and end things? Of course, the whole situation is partly tied to the change in administration and how the election played out, but still, it's no surprise Judge Torres wasn't impressed. Instead, she shut it down, saying, nope, not like this, follow the proper procedure. She wanted them to present a stronger case, something convincing enough to justify revisiting her earlier decision. But that didn't happen, and you could tell she wasn't thrilled. There were high hopes that something big was about to unfold, and when the latest filing finally dropped, well, not quite. If you were expecting fireworks, this wasn't it. But there's still plenty to unpack as we break it down. Let's dive in with the headline from Cointelegraph. SEC Ripple file motion to release $125 million in escrow as case winds down. In a joint motion filed Thursday, Ripple and the SEC requested the release of $125 million held in escrow to settle court-ordered payments. Per the filing, $50 million will go to the SEC as a civil penalty against Ripple, while the remaining $75 million will head back to Ripple, pending court. The case may be winding down, but the ripple effects, pun intended, are far from over. The filing attorney stated, and I quote, "The parties' proposed resolution will preserve the resources of the Second Circuit by avoiding the need to decide appeals, obviate any remand for further proceedings in this court, and bring 4.5 years of hard-fought litigation to an end," end quote. The SEC's lawsuit against Ripple has been a cornerstone case for crypto regulations in the US, and officially closing this chapter would mark a significant win for an industry already proving its legal legitimacy, true enough. But let's not forget the elephant in the room, the injunction. Right now, Ripple is operating under a standing injunction, which is directly impacting how it conducts business. Frankly, it's ridiculous and needs to disappear. Whether that happens remains to be seen. For now, it's a roadblock. The company isn't using XRP as a bridge currency in any US connected payment corridors. So here's the story. Though the timeline's a bit blurry. Was it a year ago? Maybe a year and a half? Anyway, at some point, we learned something surprising from Ripple. After the injunction, they started using Tether, the stablecoin, for any corridor involving the US. But here's the kicker. They're still using XRP for all corridors outside the US. And there's no sign of that changing. Ripple can keep operating. But let's be honest, this isn't the ideal scenario. In fact, it feels pretty unfair to me. That's just my 2 cents. But this piece of the puzzle is exactly why Ripple is fighting to reverse. It's a big deal and it really matters. Big thanks to attorney James K. Flolan from the XRP community for sharing this document. It's always great to have eyes on the latest updates. But not everyone's thrilled. Attorney Fred Rispoli, also from the XRP camp, had some pointed thoughts about it, and let's just say he's not exactly throwing confetti. In his words, in the latest chapter of SEC v. Ripple, "I'm not a fan of this filing. Judge Torres made it crystal clear in her last ruling that she wasn't happy. I suggested Ripple file a detailed, hard-hitting motion that laid out the SEC's failures in crypto regulation, complete with commissioner declarations and a touch of humility for Ripple's missteps. Instead, we got a quick mention of the SEC dismissals and a small nod to the SEC's crypto task force. Yikes. Fred's take? While there's enough legal backing for the court to grant it, the same was true for the last attempt, and that didn't pan out. Ultimately, it's all up to Judge Torres's discretion. Let's hope this one sticks. Fingers crossed. This feels like one of the few hiccups in Ripple's otherwise sharp legal strategy. Fingers crossed that Judge Torres sees the bigger picture and is keen to close this chapter, though my expectations are tempered. Still, the injunction isn't the end of the road. Ripple can continue selling XRP to institutions, just not like it did pre-2018. Cautious players may hold back, but the bold, forward-thinking ones, they'll see the opportunity and dive right in. Let's hope the injunction doesn't stick, but even if it does, fingers crossed it doesn't. Ripple's been playing by their rules that, let's face it, unfairly handicap them compared to their competitors. Despite this, Ripple's moving forward, and you've probably heard the big news by now. Instead of relying on Tether, Ripple officially launched their own stablecoin, RLUSD. It's no surprise they're planning to use RLUSD as a bridge currency for anything tied to the US. And while it's a smart move, here's the twist. It's still good news for XRP. Why? Every RLUSD transaction on the ledger requires XRP, so it's a win, just not the ideal one. Sure, we'd prefer XRP as the go-to bridge currency, but hey, Ripple's adapting. It's not the end of the world, just frustrating. Meanwhile, Circle's jumping into the mix, announcing their shiny new FX business without the kind of constraints Ripple's dealing with. It's an uneven playing field, no doubt about it, and yeah, it stings a bit, but this is where we are, unfair as it may be. Ripple keeps pushing forward, and that's what counts. There's an XRP community member named Sherry, and the way she talks, you'd think she's an attorney. Maybe she is. Honestly, I wouldn't be surprised. She hasn't publicly stated it, and it's not in her bio, but if she isn't, she must have some strong ties to the legal world. Her insights are sharp. Her understanding of legal documents is uncanny, and she explains things the way only a true professional could. Meanwhile, I'm just over here pretending to be an attorney on YouTube. Anyway, Sherry chimed in on this topic saying, "I'm with you on this one, Fred. I was genuinely surprised by her take on the initial request, and while I think there's a slightly higher chance of a more positive update, I'm more concerned now than I was before." Fair enough, Anders chimed in. An XRP community member posed an interesting question. What happens if the terms of reference reject the settlement? Could Ripple simply walk away and leave the injunction in place? Sherry's response was straightforward. If the rejection happens and her stance remains unchanged, nothing really shifts. Ripple would then face a decision. Continue with their cross appeal or let it go. Meanwhile, the injunction stays put, and that's arguably the worst part for Ripple. Sure, the financial hit is tough, but as I mentioned in a video the other day, Ripple isn't exactly struggling. They've got $3.7 billion in cash. Yes, that's just cash, not even counting their XRP reserves. Ripple isn't exactly strapped for cash, but even so, this just feels wrong, especially since there aren't any victims here. Let's be clear. The penalty doesn't go to Ripple's customers because, well, none of them were harmed. Instead, the money goes straight to the US Treasury. Yep, you read that right. No harm, no victims. Just a hefty fine lining government pockets. Normally, if a company messes up, penalties are paid to the people affected. But here, 0 victims. It's absurd. Years of legal battles, tons of wasted money, and for what? It's almost comical how pointless this all feels. Oh, and by the way, an attorney mentioned we might hear from Judge Torres in the next 2 weeks. We should get a response sooner rather than later. Attorney Bill Morgan, a notable voice in the XRP community, chimed in, saying he agrees it's not the strongest argument, but believes Judge Torres might grant the motion. His reasoning? She could be just as fatigued by this drawn-out litigation as the XRP community itself. And honestly, that's fair. She's the one doing all the heavy lifting, pushing this case forward. But let's not lie to ourselves. Most of us are beyond tired of this saga too. The silver lining, XRP already has legal clarity, so the outcome here doesn't affect that. For us, it's a win regardless. Still, I'm sticking with this story to the bitter end because, let's be real, it's fascinating. I can't help but stay curious about how it all unfolds. And in a bull market, even though this decision doesn't directly matter for XRP, we've seen markets react anyway. Here's a fresh take from attorney Morgan. While reading through today's Ripple and SEC joint motion to Judge Torres over lunch, he quips that it doesn't exactly get better or more compelling with each read. Still, he has a hunch Judge Torres will grant the motion anyway. So he's staying optimistic, even if the motion isn't a legal masterpiece. Interestingly, this aligns with what every legal expert seems to say about it, not their strongest work, but maybe good enough to get the job done. Attorney Morgan is back with another insightful update today. The SEC and Ripple filed a joint motion highlighting exceptional circumstances. What does that mean? They're pointing to past cases where modifying a judgment was crucial to finalize a settlement. Cases where tweaking the judgment helped avoid long, drawn-out appeals. Here's the deal. Ripple and the SEC are asking for the court to reduce the fine and dissolve the permanent injunction as part of their settlement conditions. If Judge Torres doesn't approve this motion, the settlement could fall apart entirely. No approval equals no deal, which means the legal battle continues with appeals and cross appeals dragging on. The stakes are high. Will the motion clear the path for a resolution, or will this saga keep unfold for months? Influencers have declared it over, case closed, but that's far from the truth. The outcome of the current joint motion is pivotal. Yes, it's a real hurdle, and Attorney Morgan is right to point that out. Still, I remain hopeful. Even now, my perspective hasn't changed. I believe this will resolve itself. We'll see how things shape up, and that's fine. If they must move forward and there's a cross appeal, so be it. It'll still wrap up eventually. I'm holding on to my optimism. Maybe it's a touch more cautious optimism now, but I still think things will end as expected. Time will tell. Attorney John Deaton just shared an interesting perspective. He's wondering, could Judge Torres actually say no to both the SEC and Ripple based on what's being called the weakest brief filed so far in this case? It seems neither side expects her to seriously consider denying it. Deaton had anticipated a more thorough, detailed argument outlining the exceptional circumstances required for approval, but instead, both parties decided to keep it short and simple. Why? That's the big question. Another attorney chimed in, echoing similar sentiments. This brief isn't exactly Ripple or the SEC's strongest work. It's falling short of what Deaton or many others in the legal community were expecting, and that's disappointing. Attorney Deaton will be breaking it all down on YouTube tomorrow, and you can bet I'll be watching. I'm eager to hear his take on what this means for the case moving forward. I might miss it live, but you can bet I'm checking it out later. I'm really curious to hear what he has to say. Former SEC attorney Mark Fagel jumped into the conversation with Attorney Deaton and made an interesting point. He suggested that maybe there just aren't any exceptional circumstances the SEC could argue with a straight face. At the end of the day, it seems like this boils down to one thing. There was an election, and now the SEC doesn't care about crypto. But is that legally solid? Doesn't really sound like it. And honestly, the fact we're even discussing this is because of how the election played out. I'll give them credit where it's due. I've been saying that from the start, but let's not pretend there aren't valid arguments here. On this point, I'll have to disagree. You don't need a law degree to see it. Just think about everything that went down during the Ripple case. The SEC's actions, a mess, plain and simple. They could owned up to it. As Attorney Rispoli put it, the SEC could have fallen on the sword and admitted, yeah, we messed up, but they didn't. Instead, they stuck to their guns, and plenty of opportunities to make solid arguments were left on the table. So if Attorney Fagel's stance is they didn't offer these arguments because they don't exist, I push back on that. Maybe it wasn't about the arguments not existing. Maybe they just didn't want to go there. Let's be real. There were angles that could have been explored. The playbook wasn't empty. They just didn't use it. And honestly, with a little creativity, there's always a way to argue the point. Attorney Deaton had some interesting thoughts to share, and it's worth diving into the details. Take a look at this. Someone chimed in with a comment saying, we get it. You and Attorney Rispoli think Ripple and the SEC should have buttered up Judge Torres more, but that's not what this is about. Deaton responded, explaining he actually believes there's a 70% chance the relief will be granted. I'll break it down in more detail tomorrow, he added. What I was expecting wasn't about flattery, and let's be clear, he's not taking a swipe at the legal team. These lawyers have way more experience in these types of cases than I do, and experience is life's best teacher, Deaton noted. Fun fact, the attorney who signed off for Ripple is a former SEC Director of Enforcement. I was honestly expecting the SEC to take some accountability here, maybe even a bit of falling on the sword action. Turns out Attorney Deaton brought up the point, not Attorney Rispoli, but still, where's the acknowledgement? The SEC could have admitted that previous leadership was overly aggressive toward crypto, especially after an appellate court called their actions arbitrary and capricious. And let's not forget the debt box case, where SEC lawyers were actually sanctioned for their overzealous approach. And then there's the Ripple case. Judge Netburn didn't hold back, outright stating that the SEC lawyers lacked faithful allegiance to the law. Ouch. Here's the thing. There were so many strong arguments they could have made. Attorney Deaton highlights several, and they're incredibly compelling. So why didn't the SEC go there? Maybe they didn't want to double down on the embarrassment, even with a new administration in charge. Maybe they just didn't want to throw their own team under the bus. Who knows? But what we got instead feels underwhelming. They stuck to safer ground, filing the document together, at least showing some unity. Still, it's hard not to feel disappointed. Those missed arguments could have been game changers. Instead, we're left wondering what could have been. Just a shame, really. As Attorney Fagel mentioned, the notion that no arguments exist is just not true. Of course, there are arguments, plenty of them. Get creative. You don't even have to stretch that far. It's not rocket science. Attorney Deaton lays them out clearly, and he's absolutely spot on. John takes it further, pointing out something key. Why isn't there a reference to pending crypto legislation like the Genius Act or Clarity Act? These are exceptional circumstances highlighting the kind of moves that could save judicial resources while helping facilitate settlements. Ripple, for instance, could have emphasized how unfair it is for regulatory clarity to be so close, yet still have an injunction looming over them. That kind of restriction puts Ripple at a clear disadvantage compared to competitors like Circle. And that's exactly what I was getting at earlier. Thanks to John for sparking that thought. He's right. Companies and banks aren't lining up to partner with a business under the shadow of an injunction. No doubt, some former SEC lawyers might scoff, thinking my belief in including these points shows my lack of case experience. Maybe so, but hey, it doesn't make them any less relevant. I was expecting a more compelling explanation to meet the high bar needed for a judge to rescind her ruling, one she clearly believes is consistent with existing law, whether rightly or wrongly. Instead, the filing seems to rely on the assumption that citing a couple of cases will be enough to sway her if she feels like it. To put it bluntly, the argument boils down to this. Look, Judge, elections have consequences, and this is one of them. Tomorrow, I'll break it all down for you, objectively listing the reasons why she should grant it and the reasons why she shouldn't. After that, crypto law will run a poll to see where the community stands. That's the update from John Deaton and a few other respected attorneys in the XRP space. Always appreciate their insights. But I've got to be honest, after reviewing this filing, I'm feeling a bit more uneasy about the whole situation than I was before. I'll be honest, no attorney, but I kind of assumed there'd be more to it. Maybe that's naive, but this document, it's almost a carbon copy of the last one. That's what stands out. So here we are, waiting to see what unfolds. I still leaning toward optimism, but hey, what do you guys think? Drop your thoughts in the comment section below. Oh, and just so we're clear, I'm not a financial advisor. Don't make any buying or selling decisions based on what I say or write. Seriously, that's a terrible idea.